Okay, good people. We get started today. The second part of the sources of human rights. We spent some time on civil and political rights, and we also spent some time on the Covenant on Economic, Social, and Cultural Rights last time. So this time we hope we go through the Convention Against Torture, the Convention on the Rights of the Child, Convention on the Elimination of Discrimination Against Women, and the Convention on the Rights of Persons with Disabilities. By way of recap, the knowledge points for anyone who chooses to adopt a rights-based approach to their work as social work, as justice and peace persons, as development persons, you're supposed to know the rights. And by knowing the rights, we are saying you know the normative criterion of the rights. First, the ability to distinguish whether they are civil and political rights, economic, social, and cultural rights, or group rights, and then narrowing down to the normative criterion of each of these rights, as we will be reflecting in the coming class. The next thing would then be knowing their sources. By knowing the sources of the rights, we are saying that you know the philosophical foundations and philosophical sources of the rights, as discussed by Dembour and Shostak, but you are also familiar with the legal sources. And by sources this time, we talk of the international instruments, we talk of the regional instruments, and the domestic legislation. But you would also be expected to know who the actors are, because each of these sources posit or establish duty bearers and rights holders. Okay, so when you say you are doing a course in human rights and the common good, or human rights and empowerment, or human rights for justice and peace, you ought to have these knowledge points in the back of your mind. When someone asks you, yes, you did this course in human rights, what do you know? There must be a bare minimum of knowledge of rights, a knowledge of the sources, and a knowledge of the actors. Then above all, you must know the mechanisms. Knowing the mechanisms allows you to progressively participate in the attainment of rights, challenging the situations where rights are not going well, influencing the improvement of human rights conditions, and these mechanisms are regional and international. For purposes of our course, we will concentrate on the international, the UN mechanisms, that is special procedures, treaty bodies, and the Universal Periodic Review. Ultimately, the fifth knowledge point would have to be knowledge of the conflict of rights, which is the general statement that, look here, the radical pursuit of one kind of right is likely to infringe on another because human rights are interdependent and immutable. Now, if I have spoken Greek, ask me a question, please. Anyone who hasn't understood what I've just communicated? Team, are we good?
Yes.
Rita, are we good?
Yes.
All right. Okay, so we then move on to this one we did last time. Okay, civil and political rights, norms that touch on physical and civil security, and norms that touch on civil and political liberties of individuals. We also talked about the characteristics. In the socio-economic section, we talked about, again, two categories of norms, norms that pertain to the provision of goods that meet basic social needs, and norms that pertain to the provisions of goods that meet economic needs. So social needs and economic needs. Okay. We also talked about the collective rights, which have two categories. One, again, the right to self-determination. Okay, those norms that relate to self-determination of peoples based on their political status or economic or social cultural development. But there are also norms that affirm special rights, especially of ethnic and religious minorities, such as the enjoyment of their own cultures, languages, and religions. So we said civil and political rights, socioeconomic and cultural rights, and we also talked about the group or collective rights, also sometimes called developmental developmental rights. Okay, then we move on to what we would call the sources that I just pointed out. Now, an ordinary advocate would tell you, when you ask them what are the sources of the law, they will tell you the Constitution. Yes, the Constitution of Kenya, for example, has Article 2, which talks about the supremacy of the Constitution, but it, however, in Article 2.5 says that the general rules of international law form part of the law of Kenya, and that any treaty or convention that is ratified by Kenya ordinarily forms part of the law of Kenya under the Constitution, right? Then the Bill of Rights. The Bill of Rights, in Articles 26 to 51, you will see the human rights contained in there. You will see the civil and political rights, and will see the social and economic rights between Article 26 and Article 51 of the Constitution of Kenya, which is Chapter 4 generally. And then Articles 52 to 57 would talk about the developmental rights or the group rights that I just mentioned above. Now, following up from these treaties that Kenya has ratified, we talk about these international human rights instruments, or human rights treaties, okay? The ICESCR, the ICCPR, the ICERD, okay, CERD, then the CEDAW, then CAT, Convention Against Torture, the CRC, okay, the Convention for the Protection of Rights of Migrant Workers, Convention on the Rights of Persons with Disabilities, Convention on the Protection of All Forms of Enforced Disappearances. Now, we also have regional instruments that Kenya has ratified, and it has ratified all of them, okay? What is called the Banjul Charter, the African Charter on Human and People's Rights, which was adopted in 1981, came into force in 1986, and has been ratified by up to 53 African nations. Kenya has also ratified the African Charter on the Rights and Welfare of the Child, which was adopted in 1990, came into force in 1992, and has been ratified by 41 African nations. Kenya has also ratified the protocol to the African Charter on human and people's rights with regard to women in Africa, adopted 2003, came into force 2005, and has been ratified by 36 nations as of now. And this is 36 out of 54, 54 African nations. However, Kenya has not ratified in the international system the Convention on the Protection of All Persons from Enforced Disappearances. Neither has it ratified the International Convention on the Protection of the Rights of All Migrant Workers and members of their families. Okay. Now, you are aware that in Kenya we've had this situation of extrajudicial killings, the security forces abducting young people, and they get to be found either floating in riverbeds or in forests and things like that. So because of that situation of enforced disappearance, I think the government of Kenya has been reluctant to commit, all right? And it's been like this since the Moi era. It didn't change a lot, okay? Security forces usually do this, and it is normal for governments to not commit to conventions which they know they are already breaching, which they know they may not be able to fulfill. So that rights workers like you and I would have to work towards persuading governments to commit, doing the necessary participatory and activist action within the country to ensure the government actually commit. Now, for those of you who are not Kenyan, you can do such an analysis for your own country, and you will discover which international human rights instruments your country has ratified and which ones it has not, and why you're able to establish that. So that's what it means, knowing what the sources are for purposes of human rights in your country. Okay, so we now reflect on the Convention Against Torture and Other Cruel and Inhuman or Degrading Treatment. Okay, it's a 1994 document by adoption that came into force in '87, and Kenya ratified it in 1997. Now, torture is defined as any act by which severe pain or suffering, whether physical or mental, and that this is intentionally inflicted on a person for purposes of obtaining from them information or a confession. Now, you're aware that sometimes espionage or intelligence organizations are in the habit of grabbing people, taking them into difficult situations and trying to extract information out of them. This was very prevalent during the Cold War era, and it explains why nations pulled together to make this kind of commitment to protect people from torture. Now, governments have a duty to respect, to protect, and fulfill human rights. Governments respect human rights by desisting from being the aggressors and the offenders. Governments protect human rights by making sure third parties do not infringe on rights of humans and individuals, and states are expected to fulfill human rights by taking positive measures to guarantee those rights. Okay, now, especially if that pain is extracted by the actions of a public official, that would be a huge failure on the part of government to protect, respect, protect, and fulfill. Now, we know that pain does not include that pain or suffering that arises from inherent or incidental to law sanctions. I mean, you cannot say that because someone has been sentenced to jail and that in jail, actually, they used to have corporal punishment by law. In many countries, there used to be, you jailed, but you also receive lashes of the cane every so often. Now, as long as that is still on the law books of any country, and you get sentenced to jail with caning, okay, then that kind of pain would not be treated as torture. But again, that is largely dependent on whether the kind of punishment prescribed in the law would be that. But in general, the Convention Against Torture, just from its name, condemns caning. It would be treated either as cruel or as inhuman or as degrading. You know, you whip a horse, you whip an oxen to drive the the plow, okay? Would you then whip a human being? Would that be human if you lashed a human being? So state parties under the Convention Against Torture are obligated to take effective legislative, administrative, judicial, other measures to prevent torture. They cannot expel, return, or extradite a person to a state where there are grounds, substantial grounds to believe that such a person would be subjected to torture. So the convention also criminalizes torture. And that depending on their gravity, people who torture others should be punished by the law. And state parties are also required to apply similar criminal penalties to any attempt to commit and complicity or participation in torture. Now, when does criminal jurisdiction arise? Under article of the Convention Against Torture and all forms of cruel, inhuman, and degrading treatment, short form CAT, the offenses are committed in any territory under the jurisdiction or on board a ship. Okay, the alleged offender is present in any territory under its jurisdiction, and the state does not extradite him in accordance with Article 8, which makes torture an extraditable offense. Now remember, we said that the convention does not allow states to extradite people who it knows that if they were extradited, they would be returned to a country where they are going to be tortured. However, someone who has committed torture in one country is extraditable under the convention. Do we have any questions on the Convention Against Torture? Do we have any questions on the Convention Against Torture? Okay, so we also talked about the human rights, the Committee Against Torture, and this is the treaty body established under the Convention Against Torture to monitor the performance of states with regard to the specific treaty. Okay, and we say that each state party is required to submit within a year of the convention into force a report to the committee detailing the measures it has taken to give effect to the provisions of the convention, as well as supplementary reports every 4 years. Now, I don't remember when Kenya was last reviewed, but for many countries, they took long to start filing these reports, and they've just started recently to file combined reports of these to these treaty bodies. Now, if you're not Kenyan, you can check already and figure out how often your country has filed reports under the Convention Against Torture. Okay. So final call, do we have any questions about the Convention Against Torture? What it is about and its relevance to your work? Do we have any question? Hope Mungai, do you have any question?
No, I'm okay. I am okay.
What course are you doing, Hope Mungai?
Development studies.
Why should a development studies student know about the Convention Against Torture?
It is relevant when one is dealing with a project, maybe for example.
It is what?
That involves dealing with. I think it comes in handy when one is maybe dealing with a project that involves, in quotes, sorting out people's human rights.
Other development workers are not concerned about this. Only those with a project on human rights.
I've said, for example,
I want to imagine yourself in the development field. Why would you have to know about this convention? What value would it add to your service?
Having the knowledge to be able to deal with
Rita, would you like to respond to that question? Team, would you like to respond to that question?
I think as a development officer or someone who practices development, it is important first to know things that negatively impact the processes that you're trying to promote. So the Convention Against Torture will assist you to know what you're trying to work towards and what you're trying to stop or eradicate.
Let me bring it closer home. What is the relevance of this convention today in Kenya? Is there any relevance? Wangeshi? Wangeshi? Someone is registered as iPhone. Who is it? Someone is signed in as iPhone. Could you please share what your views are on this question?
It is to ensure accountability to acts of torture.
Yeah, but the question is, I'm asking the relevance of this convention to Kenya today. What accountability has to be done? What are the issues Kenya is dealing with right now that make this convention relevant? Do you guys ever listen to the news? Do you know what is going on in the country? Hope, where do you live?
Ongatagongai.
Rita, where do you live?
Rongai.
Tim, wapi?
Kabete.
Wangeshi, wapi unaishi?
Kikuyu.
Okay. Are there things happening in your neighborhoods that make this convention relevant?
Can you say like the police brutality that was there during curfew?
Uh-huh. Mm-hmm. What else? That's right. Someone, who is this iPhone person? Talk to us. Unaitwa?
Jenna.
Unaitwa?
Jenna.
Jana.
Jenna.
Jenna is your name, okay. Tell us, what's the relevance of this convention? All right. We will keep moving. You guys seem you like me to just keep talking. All right. So we then have the Convention on the Rights of the Child. It gives social rights, economic rights, cultural rights, protective rights, civil and political rights as they relate to children. Remember, the primary conventions are instruments were the Covenant on Civil and Political Rights and the Covenant on Economic, Social, Cultural Rights. Then we get the conventions, remember? Covenants, 2 covenants, and then 7 conventions. Now, this convention on torture is domesticating civil and political rights in the context of torture, largely as it relates to, for sure, the disciplined forces, members of the intelligence operations and things like that. Now we are talking about the Convention on the Rights of the Child, and it is actually bringing home the rights in civil and political rights and the rights in socioeconomic and cultural rights into the context of children. Okay? What would social rights mean? What would economic rights mean? What would cultural rights mean? What would protective rights? What would civil and political rights mean for children? And we must take note that these rights are indivisible and universal. Indivisible, you cannot treat them as individual rights, dividing them and slicing them. No, 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 no. They are taken together. They are universal. What is good for a British child with regard to human rights is good for a Kenyan child with regard to human rights. There is no right that is superior to the other. That's what is meant by there is no hierarchy of rights. Rights are rights. Now, the underlying principles of the Convention on the Rights of the Child are contained in Article 2. All rights in the Convention apply to all children without discrimination on any grounds, universality. And in all actions affecting children, the best interest of the child must be the primary considerations. Now, the social workers on the call, if any, and development workers, you know that the welfare principle is paramount. Where a decision has to be made on any issue, and there is a child involved, whether directly or remotely, then the best interests of that child must be the primary consideration. All children have the right to life and optimal survival and development. Actually, the Convention on the Rights of the Child in the preamble says that based on the vulnerability of children, they are entitled to protection before, during, and after birth. Okay, protection of children in the womb is articulated in the Convention on the Rights of the Child. Preborn children are to be protected just as equally as the children who are born. Now, all children capable of expressing a view have the right to express that view freely and to have it taken seriously in accordance with their age and maturity. Now, human rights fall into 3 broad groups. Rights that extend to both children and adults, rights that extend to adults but not to children, and rights that extend only to children. Now, rights that apply to children and adults. These would include the right to life, freedom of expression, education, due process before the law, meaning the right to be, in Kenyan Constitution, it is, I think, Article 59 and Article Article 58 and 59, I think, yeah, where they talk about the due process before, no, Article 49 and Article 50, where they talk about the due process before the law, the rights of an accused person, the rights of an arrested person, and all those rights which require that someone is treated with dignity even when they are suspected of having committed a crime, and the principle of non-discrimination. Now, the rights of adults that would not extend to children would be the right to vote, autonomy to take decisions independently of those who have responsibility over them, and also the right to the adult to self-determination. You see, adult rights to self-determination are usually limited with regard to children. Allow me to silence my people. Okay. Now, these rights that apply only to children will be rights to play, to have their best interests given primary consideration, the protection from abuse and exploitation, and to alternative care where the families cannot provide it or are failing to provide it. These are rights that apply specifically to children. So those of you going to be working in the area of social protection, child welfare, this Convention on the Rights of the Child is going to be your document. It would be necessary to be familiar with it. And then we reflect on what the convention does. It promotes a philosophy of respect for children, recognizes children as subjects of legal rights, challenges traditional views of children as passive recipients of care and protection, insists that children are entitled to have their needs met, and thereby enforces obligations on adults to meet those rights of children. So adults are usually placed in the category of duty bearers towards children, though in principle it is supposed to be the state that is the duty bearer, or its state functionaries that are duty bearers, and the children would be the rights holders. Now, the convention requires that governments implement the convention's right without discrimination for all children, to make the convention widely known to both children and adults. And that is the second component of fulfilling rights. Fulfilling rights involves even awareness raising, making people know what these rights are. And also governments are required to report regularly to the Committee on the Rights of the Child. The Committee on the Rights of the Child is the treaty body founded under the Convention on the Rights of the Child to monitor the performance of states with regard to the rights of the child. So states would have to be filing reports regularly. So as we said earlier, you would see social rights, economic rights, protective rights, and cultural rights, and civil and political rights contained in the Convention on the Rights of the Child. Now, some examples of socio-economic rights contained in the Convention on the Rights of the Child, you would have social rights, for instance. Social rights would be the right to life and optimal survival, the right to development, the right to the best possible health and access to health care, the right to education, the right to play, the right to family life, unless not in the child's best interest. So we will not force the child to be in a family which is abusive, because by that we would say that, look here, it's not in the best interest of the child to be in the family. But if the family is not abusive, then it is in the best interest of the child to be in the family. Then economic rights. The right to an adequate standard of living for proper development. And the right to benefit from social security, the right to protection from economic exploitation. Those would be social rights, those would be economic rights. What would the protective rights then be? Under the Convention on the Right of the Child, we would find provisions in there that affirm the right to promotion of the child's best interests, provisions that affirm the right to protect the child from sexual exploitation, from armed conflict, from harmful drugs, from abuse and neglect, you know, the right to rehabilitation and care in case of neglect, and the right that protects them from abuse and exploitation. So the protective rights, okay, when you look at the Convention on the Right of the Child, you'll find provisions here and there that are protective in character. So there'll be social rights, there'll be economic rights, there will be protective rights. Now, casual rights would be the situation where we have the right to respect for the language of the child, the culture and religion of the child, abolition of any traditional practices that are likely to be prejudicial to the child's health. And it could be in this area that we have people fighting female genital mutilation as it affects children. So yes, cultural rights is that wide enough: language, culture, religion, abolition of dangerous traditional practices. That would be the kind of the provisions you would count on if you are in that area of cultural rights. You have to verify how the practice of cultural rights is affirming the rights of children. Okay. Okay. So some of the civil and political rights contained in the Convention on the Rights of the Child would be the right to be heard and taken seriously, the right to freedom from discrimination in the exercise of the rights on any grounds, freedom of expression for children, privacy. You know, UNICEF has generated an entire document on what privacy of children would mean, especially on the internet. I'm dealing with a situation where my daughter's phone number gets, okay, it's my number, but it is in her hands, gets added to groups that she has not signed up for. Just wakes up in the morning and finds, hey, I've been added to a group that is talking about all sorts of weird things, you know. So isn't that an invasion of privacy? How would we enforce the convention in that respect? And the right to information, the right to respect for physical and personal integrity, and to freedom from all forms of violence, all cruel and inhuman and degrading treatment. So it is this right actually that was used in various jurisdictions to outlaw corporal punishment in schools. Okay, so with the question of the Convention Against Torture and the Convention on the Rights of the Child, all of them agreeing that human beings should be free from all forms of violence, all cruel, all inhuman and degrading treatment, then we got young people protected in that sense. Do we have any questions on the Convention on the Rights of the Child? Do we have any questions? Shall we get into the chat room and respond to the question? Do we have any questions? You just type yes or no in the chat room. Okay. Shall we proceed? Yes or no? Okay, it would seem that only 3 people are active in the class. Good. Okay, let's go on. So we then have the Convention for Elimination of All Forms of Discrimination against Women. Now, CEDAW was adopted in 1979 by the UN General Assembly. And as of now, 180 countries have signed it. We would say it is the International Bill of Rights for Women. And it defines what constitutes discrimination against women. And it sets out what would be an agenda for national action to end discrimination against women. It is considered a radical treaty by the fact that it aims to transform the structural barriers to equality between men and women, and it addresses the multifaceted nature of problems that women face. So the core principles in the CEDAW are equality and non-discrimination. So equality between men and women, and then non-discrimination. Substantive equality. By pursuing substantive equality, the Convention promotes equality of opportunity through law, through policy, programs, and institutional arrangements. Promoting equality of access by eliminating all obstacles that prevent access to the opportunities and taking positive steps to ensure goal of equality is achieved, and then equality of results. So equality of opportunity, equality of access, and equality of results. You're aware that the Constitution of Kenya is under review and the proposals are being made. Actually, one of the closest to the question of equality and non-discrimination after they had been blunted failure by Parliament to pass a law that would affirm the 2/3 gender rule. Now, the proposal in the BBI actually is to have up to 94 senators. Then the speaker would be 95 in total. But yes, 94 senators, where you have 47 male senators per county and 47 female senators per county, right? So that is with regard to equality of opportunity, and then equality of access, and hoping for equality of results. The principle of non-discrimination in CEDAW affirms the view that discrimination is socially constructed. Discrimination is not a natural principle of human interaction, and there should be recognition of the need for concerted action against inequality and the institutional mechanisms that perpetuate it. So CEDAW has provisions on discrimination, special measures, cultural practices, trafficking, politics, nationality, health, employment, education, law, marriage, family benefits, and a specific consideration for rural women. Discrimination in CEDAW is defined as any distinction, exclusion, or restriction made on the basis of sex, which has the effect or purpose of impairing or nullifying the recognition, enjoyment, or exercise by women, irrespective of their marital status, on the basis of equality of men and women, of human and fundamental freedoms in the political, economic, social, cultural, civil, or any other field. Now, a change in traditional role of men as well as the role of women in society would be needed to achieve full equality between men and women. So CEDAW is out to make sure that the traditional stereotypes held between men and women are challenged, are corrected, especially if they are responsible for inequality between men and women. And remember, this inequality relates to inequality of access, inequality of results, and inequality in substance. So state parties are expected for purposes of health to take appropriate measures to eliminate discrimination against women in the field of healthcare in order to ensure access to healthcare services, including those that relate to family planning. Now, for sure, the reporting process of CEDAW. Now, CEDAW in this sense is being used as the Committee on Elimination of Discrimination Against Women. Okay, the Committee on Elimination of Discrimination Against Women is the treaty body established by the Convention on Elimination of Discrimination Against Women to monitor the performance of the states in fulfilling these rights. So when a government ratifies CEDAW, it commits to put in place legislation and policy to ensure women's equality. And for sure, every 4 years, government submits a progress report to the CEDAW committee, as in to what extent has the government attained its obligations under CEDAW. Government is then examined at a session of the CEDAW committee on its report and on the issues raised by alternative reports from civil society organizations and women's groups. Now, the CEDAW committee, which is the treaty body, is a 23 expert member group selected from across the world for their disposition in matters non-discrimination in matters women. Okay, they would meet twice annually at the UN in New York. Actually, CEDAW is the only treaty body that has maintained presence in New York. Many other treaty bodies are in the UN office in Geneva. Okay, so meeting twice annually, and they have up to 8 governments that would report in each of these sessions. So a total of 16 governments would be reviewed every year. And after a government has been examined, the committee produces what is called concluding comments or concluding observations, wherein it outlines its concerns about the government's position or state of the government on matters women discrimination, and then it provides recommendations. So far, do we have any questions on discrimination against women? Chat room, please tell me, do you have any questions on the matter of discrimination against women?
Yeah, I have a question.
Yes.
About the 23 experts on women's issues from around the world. The 23 experts, are they women only, or are they a mixture of men?
No, they could be men. It's 12 hours. The point is experts. So that it could be men or women that would have to be recruited by the UN system from across the globe. It doesn't have to be 23 women. Fair enough?
Yes.
Mm-hmm. Any other question? I take that to mean we proceed and we move on to the Convention on the Rights of Persons with Disabilities. I've selected these specific instruments because they are the instruments largely connected to development practitioners. People who do development studies end up in development work that is touching on persons with disabilities or children all women, or youth, or things like that. So that's why I have identified these conventions as the closest to give an overview on, okay, when we talk about sources, where would you look? Okay, get employed and you land into the National Council of Persons with Disabilities, you already know that this is the document for you. When you land into social protection, chances are you're going to have to be dealing with the Convention on the Rights of the Child. If you landed in any of these women organizations, you will see CEDAW coming out prominently. So you need to know where these rights are coming from. When we say sources, where do you look for these rights? And don't wait until you are in the field practicing for you to familiarize with these instruments. It is necessary that you are familiar with them in advance. Usually, very useful disposition at interviews, your knowledge of the human rights instruments and their content, okay, as they apply to a job environment, puts you a step ahead of others. And as we said, this course is going to be as practical as possible. I'm glad some of you have already done the tracing assignment. So you've already been able to look at these various instruments and identified how the right you are assigned applies. So yes, the Convention on the Rights of Persons with Disabilities, also short form is CRPD, okay? There lies the structure of the Convention on the Rights of Persons with Disabilities. And when you see the structure, you'd see that the rights range from civil and political rights to economic, social, and cultural rights, but you'll also see the group rights, okay? Women with disabilities are a group in themselves. Children with disabilities are a group in themselves. There are issues that they share in common, the challenges they share in common, so that a response to them ought to be focused on them as children with disabilities, as women with disabilities, and men with disabilities would also have to come up. Okay. So we then reflect a little bit on why we have a convention on the rights of persons with disabilities. This convention came out as a response to an overlooked development challenge. It turned out that actually 10% of the world's population are persons with disabilities. Now we are already at the 7 million mark, so 10% would actually mean close to 700 million people. And approximately 80% of these live in developing countries. So you're talking of development, you are targeting development of Africa, which is close to 1 billion people. So for sure, 80% of 7 million people would place us at 7 million times 8, would close us to 600 and something million. Okay, yeah, close to 600 million people in Africa. Okay. Okay, would be with having disabilities. Not in Africa, but in developing countries. You see, many times I make the mistake. Yeah, developing countries doesn't necessarily mean Africa. We have Asia, we have Latin America, so they are spread across these continents. There are many persons living with disabilities. So if you're dealing with solving development issues, and you do not have a human rights document specifically speaking to the rights of persons with disabilities, you are only doing a portion of the work. It was also a response to the fact that although pre-existing human rights conventions offer considerable potential to promote and protect the rights of persons with disabilities, this potential was not being tapped. And persons with disabilities continued being denied their human rights and were kept on the margins of society in many parts of the world. So the Convention on the Rights of Persons with Disability was setting out the legal obligations of states to respect, protect, promote the rights of persons with disabilities. This Convention on the Rights of Persons with Disabilities does not create new rights. It only contextualizes human rights in the context of persons with disabilities. For sure, you have civil and political rights. For sure, you have economic, social, and cultural rights applicable to the general population. But how would these rights apply to persons with disabilities? Just as you are able to make these rights apply to children, you were able to make these rights apply to women. How then do these rights apply to persons with disabilities? So generally, the Convention's purpose is to promote, protect, and ensure the full and equal enjoyment of all human rights and fundamental freedoms by persons with disabilities. The Convention also sets out a long list of obligations on state parties. And while each provision in the CRPD sets out the various actions that state parties must take to promote and protect the specific rights, it constitutes a paradigm shift. A paradigm shift is a shift in the frame of thinking, okay? Because in its attitudes and approaches to persons with disabilities, there is a shift in how states had been handling persons with disabilities before. Persons with disabilities are not viewed as objects of charity, medical treatment, or social protection, but they are to be viewed as subjects with the rights who are capable of claiming those rights and making decisions for their lives based on their free and informed consent. And the Convention gives universal recognitions to the dignity of persons with disabilities. Now remember when we talked about this adoption of a rights-based approach, I need to restate it. For a long time, development was dealt with in stages of, first and foremost, the needs-based approach. So for a long time, development meant provide needs to the needy. People don't have food, you provide relief. People don't have houses, you invest in housing corporations and things like that, okay? Needs-based. Then came Amartya Sen, who made a strong proposal in favor of the capabilities approach. Let's build capabilities. Let's make sure that our development programs guarantee people's capabilities. That was the shift, the capabilities approach, or the empowerment approach, empower the people. And empowerment was at skills and knowledge and attitudes, you know, all those things necessary to make sure if you cannot feed yourself, you can feed yourself, okay? You know how to look after the animals and things like that. Now the challenge came this way. We had already the needs-based approach, you had the capabilities approach, but you still had poor people, okay? You've trained people how to grow coffee, you've trained them how to grow beans, they have grown the beans, they have grown the maize, but they cannot sell. Or when they go to sell, the prices are terrible, okay? Then what do you do with such people? It is only the human rights-based approach that is capable of dealing with this situation, because the rights-based approach grants us duty bearers and rights holders. And these duty bearers and rights holders relate by way of accountability. Duty bearers are accountable to the rights holders, and rights holders have a duty to participate and hold the duty bearers to account. So it is in that spirit that the Convention on the Rights of Persons with Disabilities comes in, to make sure the persons with disabilities are capacitated to be authentic rights holders to hold duty bearers to account. Can take a breather. Okay. So what would we say disability is? Even though the convention does not explicitly define disability, it refers to it as an evolving concept resulting from interaction between persons with impairments and attitudinal or environmental barriers that hinders full and effective participation in society on an equal basis with others. Persons with disabilities include those who have long-term physical, mental, intellectual, or sensory impairments, which in interaction with various barriers may hinder their full and effective participation in society on an equal basis with others. So we would say that disability results from an interaction between a non-inclusive society and individuals who, as a person using a wheelchair, might have difficulties gaining employment, not because of the wheelchair, but because there are environmental barriers, such as inaccessible buses, stairways without ramps, and all these would impede access. Now, persons with extreme nearsightedness who do not have access to corrective lenses may not be able to perform daily tasks. And such persons with prescription eyeglasses would be able to do all the tasks without problems. Okay, so it is this general interaction with the. Now, the Convention on the Rights of Persons with Disabilities uses the phrase persons with disabilities. It does not recognize the term handicapped. It does not recognize physically or mentally challenged, physically challenged or mentally challenged. So you have to take note that preference for terminology among persons with disabilities and among geographic regions may vary from one to another. The individual wishes of a person with disabilities should also be respected as much as possible. Okay. I used to use the term hearing impaired when I'm interacting with the deaf, but in Nairobi, the school for the deaf guys, so no, it is okay. They can be called deaf people. It is not offensive to them. You know, so the general principles here is that there's respect for inherent dignity, individual autonomy, including the freedom to make one's choices, non-discrimination, full and effective participation and inclusion in society, full effective inclusion with regard to participation. You know, it is one thing to say it is another thing to make it happen. Okay, what does full and effective participation mean for persons with disabilities? What has to be done to make sure they fully participate in societal activities and initiatives? Respect for difference and acceptance of persons with disabilities as part of human diversity and humanity. Equality of opportunity. Are they competing in the same manner with others? Accessibility. Equality between men and women. respect for the evolving capacities of children with disabilities, and respect for the right of children with disabilities to preserve their identities. Participation and inclusion. It is important to correctly identify specific needs and to empower the individual. Full and effective participation and inclusion in society is recognized in the Convention as contained within Article 3, 4, and Articles 29 and 30. First, as a general principle, participation and inclusion, but also as a general obligation, a principle that guides the Convention on the rights of persons with disabilities. It is generally about participation and inclusion of persons with disabilities. But it is a general obligation on all duty bearers, and in this case, the states, but also as a right, probably categorize participation and inclusion. The rights, the persons with disabilities have a right to participate, have a right to be included. Then the general principle of non-discrimination. It is a known fundamental principle of international human rights law. It includes direct and indirect discrimination. So the principle of reasonable accommodation must be made for persons with disability. And reasonable accommodation means necessary and appropriate modification and adjustment. Necessary and appropriate modification and adjustments, not imposing a disproportionately undue burden where needed in a particular case, just to ensure that persons with disabilities are able to enjoy or exercise on an equal basis with others of all human rights and fundamental freedoms. Necessary and appropriate modification. Schools, can they be accessed by persons with disabilities? And what would access mean in a school? Is it enough that you have ramps and that wheelchairs can go up? What about the blind students? Do we have software in our system that allows for that? Right now, I'm talking to you, but I don't know what deaf students would have to do in such a class. A class such as ours would actually be non-inclusive. It would be actually discriminatory against deaf students. A situation where you all have to survive on hearing what I have to say. Okay? Would universities, would colleges be able to include the deaf persons? Would they be able to reasonably accommodate deaf persons in the situation in which we are? Would the translations going on television with the news, would those be able to be incorporated in a teaching environment so that the deaf students could benefit from this learning that is going on? So the principle of accessibility, okay, it's important as a means of empowerment and inclusion, both a general principle and a standalone in Article 9. Access must be ensured to justice, so access to justice, access to opportunities to live independently and to be included in the community, access to information and communication services, access to education, to health, habilitation and rehabilitation, work and employment, access to an adequate standard of living, access to participation in political and social life, and access to participation in cultural life, recreation, leisure, and sports. So when we talk about the principle of accessibility within the context of persons with disabilities, that is the repertoire of of rights that relate to accessibility. So then we have that general list of rights as they are contained in the Convention on the Rights of Persons with Disabilities. Then the article that talks of international cooperation in promoting the rights of persons with disabilities. So, do you have any question for me with regard to sources of rights? Do we have any questions with regard to sources of rights? Okay. Now, since you people choose to just keep quiet, I'll keep talking to myself. So, by this time, it is necessary that people have turned in. I have 5 out of 13 who turned in the assignment on what are human rights. I hope that all those of you on the call have all turned in that assignment. We have another assignment that was due on 16th October, which was relating to tracing the provisions of the rights. I have 7 out of 13. I don't know where the other 6 or so are. And very soon we'll be dealing with the normative criterion of rights, but I think I'll post that assignment after next week's class so that you are able to maneuver. Do you have any questions for me? Do we have an idea what the rights-based approaches are to development? Are we comfortable with the sources now? Okay. So I'd encourage you to go ahead and interact with the normative criterion of the rights, because that's the next step that we're dealing with. Each of the rights that you are given has a normative criterion. Let me see if I can demonstrate how to get the normative criterion. I did that at one of the classes, I think the first class or something, but I'll do that again. Yeah. So let's see. As I told you, the Office of the High Commissioner for Human Rights is your office. If you are a student of human rights, you ought to be a regular visitor to the Office of the High Commissioner for Human Rights. And when you are at the Office of the High Commissioner for Human Rights, you go to human rights bodies and check on the treaty bodies. Okay. And the treaty bodies will tell you that they deal with the core international human rights instruments. When you get this table of the international core human rights instruments, I would encourage you, I know you've already been through these, you're tracing where your specific right is assigned. But when you check on the monitoring body, for example, the Committee on Economic, Social, and Cultural Rights, mainly the rights that I gave you to examine are contained in the convention, in the Covenant on Economic, Social, and Cultural Rights. So you would go to the page of this Committee on Economic, Social, and Cultural Rights and do one thing. And you look for what is called the general comments. Okay. The general comments of this committee, of this treaty body, will provide you specific comments that have been made with regard to each of your rights. So those of you dealing with food or health, we say health, you would already see that a number of general comments are dealing with the question of health. The most recent one, I think, is the one that is explaining sexual and reproductive health. But if you listed it up to 50, you would be able to find more provisions on health. Okay. So general comment number 14 would be a good source for those who are dealing with health, then food, quite a number of, then housing. Okay. So each of these general comments has normative criteria. I use the word normative criterion deliberately. Those norms that the relevant treaty body has established as indicators for whether the specific government in question is meeting its obligations with regard to that specific right. So I would encourage you to already start investigating the normative criterion of the right that was assigned to you. Okay. Actually, I think I should activate this assignment. I should activate this assignment since I've shown you how to deal with it. Do you understand what I've just asked you to do? Anyone is listening to me?
You have a question?
Yes.
When looking for the normative criteria, are we only focusing on that particular treaty body you've highlighted, or we are focusing on all the 9 instruments?
No, the treaty body that is most relevant to the rights I assigned you is the Committee on Economic, Social, and Cultural Rights. It is the committee that is likely to have thoroughly explained the rights you're dealing with through its general comments. If you went to other treaty bodies, you would find reference to these rights, but it would be superfluous. For knowledge purposes, I would rather you navigated the page of the relevant treaty body so that you find out the normative criterion from a relevant general comment. So I would expect that if you're dealing with housing, you know the relevant general comment and you know the specific normative criterion generated therefrom. Tim, did I respond to you?
Yes.
Yeah. The intention is to try and narrow the search. I cannot be sending you to run helter-skelter. So this is, yeah. We'll do that as November 10th. With the possibility for late comers. Yeah. This one is usually a big assignment, so I give it 20 marks usually. Okay. So, yeah. So let's let it be. If you don't have any questions for me, we could end here for now. Anyone else has a question? So let's meet next week. Hope you will have started on covering your normative criterion and you come to class with questions for me.